Hello, my brothers and sisters. Today we are going to see RTP, where I just want to make sure that one day before exam you have to know the provision of this. So that what I will be doing is I'll be reading the question. We have less number of hours before the examination, one day before the examination. So I'll make sure that you have to know what are the provisions. So I'll be writing the side, then what is the provision. You just take the screenshot of it, or if you have already taken a xerox of RTP, or if you have any book, then you can write it side in the side. Yeah, and we are not going to read the entire question. I have already marked it. We are going to read it and we are going to solve it. Yes, superb. So before we start, just subscribe to my channel. So let's start. ABC Limited was incorporated on 1st Jan 2023. Includes e-commerce operations. Board is preparing its first annual general meeting. Present. Discuss the new business model. The company has a wholly owned subsidiary XYZ Limited involved in research and development. 30% stake is an associate company MNO Limited. Solve the MCQ. Given that ABC Limited's first financial year ended 31st March 2024 and it was incorporated on 1st Jan 2024. When was it incorporated? 1st Jan 2023. Sorry, 1st Jan 2023. What is the latest date by which ABC Limited must hold its first AGM? Tell me, what is the provision? First AGM, 9 months from end of the first financial year. So what is the first financial year? 31st March 2023. So I'm sorry, first financial year 31st March 2024. So the 9 months means 31st December 2024. Sir? Yes. Next, suppose question number 2. Suppose ABC Limited holds its first AGM on 15th December 2024. First AGM on 15th December. Actually the due date is 31st December, but it has conducted on 15th December 2024. Then it's okay, no problem. By when must it hold its subsequent AGM? What is the provision? 6 months from the end of the financial year. This along with it, what is the other point which is important? And 15 months, there should be a time gap between the two annual general meetings. Yes, so because it is conducted on 15th December 2024, there is no problem. Both the conditions should be satisfied. So which means this is the answer, 30th September 2025. Yes or no? Because 15th December 2024 plus 15 months comes to 2026. You have to satisfy this also, and within 30th September 2025. So answer is B. Next, question number 3. Under Companies Act 2013, does ABC Limited need to prepare consolidated financial statement to present the annual general meeting? What is the answer? Answer is yes. Why? You have to prepare. Why? Because you have a subsidiary. Yeah, has a subsidiary. So required to prepare CFS. Sir, yes. Because it is having a one wholly owned subsidiary, and also it is having an associate company also. What must ABC Limited ensure to pass a special resolution approving the adoption of new e-commerce business model? So the answer is, the resolution must have more than 50% vote in favor. Answer is no. The resolution must be stated as special in the notice. Yes, if it is a special resolution in the notice, you have to mention it as special. And vote in favor must be 3 times the vote against. Yes or no? Yes. Answer is B. Next, under which conditions would ABC Limited be exempt from preparing the consolidated financial statements? Tell me, what is the provision? I'll write down like this: the ultimate holding company. Next, the intermediary holding company and the subsidiary company. Yes. So for this company, if they don't want to prepare, if they want to claim exemption to prepare CFS, what should it do? One, it should not be a listed company. Two, not be a listed company, or it should not be intent to get it listed. Or next two, the ultimate holding company should prepare CFS. Three, there is no objection by the shareholder. Everyone has consented it in writing. So the answer is, if ABC Limited is a wholly owned subsidiary, all members agree in writing to exemption and proof of delivery of it is in. Yes, answer is A. Sir. So yes, answer is yes or no. Answer is A. You don't need an anonymous. You don't need no significance. Or no, you don't need this also. Skip. Board's majority. No. Answer is A. Next, question number 6. Partner B, without consulting the other partners, enter into a contract. Partner B did not have the authority to engage such deals. The history of involvement in the procurement. Mr. P, aware of partner B, who's Mr. B? Who's Mr. P? He's a business person, is aware that the partner B was not authorized to enter into the procurement deal for XYZ LLP. Is this scenario, which of the following is correct based on LLP? Tell me, what is the provision? 1. The outside authority of the partner. If he is going outside the authority of the partner, and right, and 2, the third party is aware that he does not have the authority. Yes, in this situation, B, he is going outside the authority, and the third party, Mr. P, is aware that he does not have the authority. So the answer is D. XYZ LLP is not bound by the contract as a partner B lacked authority, and Mr. P knew the lack of authority. Yes. So the LLP is not bound by the contract. Question number 7. Miss Rani resigned. Hope you are taking a screenshot or you're noting it down. Miss Rani resigned from the LLP on 1st Jan, running the business without admitting new partner, aware that he was only remaining partner on 1st August, incurring debt of 5 lakhs. What is the provision? Within 6 months. Within 6 months. You have what? You should have minimum number of partners. So a new partner to be appointed for so minimum partner in LLP is satisfied. Yes. So if you are not appointing the new partner, then the partner present will be personally liable. Sir. So what is the answer? B. Mr. Raj will be personally liable for 5 lakh debt since he was the sole partner of LLP for more than 6 months. Yes. Question number 8. Amit, who is a chartered accountant, appointed auditor of a Grey Limited, Miss Anita, who's Mr. Amit's wife, acquired the company's equity shares of face value 1 lakh. Tell me, is he disqualified? Answer is no. Why? Up to rupees 1 lakh face value. If you have purchased, no disqualification. Yes? Yes or no? Yes. So the answer is within 30 days can continue. Miss Amit and company can continue as the auditor. Yes, since it did not exceed the limit. Question 9. XYZ Limited is a company with 51% of equity shares held by the state government. Tell me. So what are they asking? Which of the following statement is correct? Who will be appointing? Sir, government company. Not less than 51% of total voting power. Yes, so which means for a government company they are having 51%. Yes, so which means the state government is having 51%, so it's a government company who will appoint comptroller and auditor general will appoint the auditor. Yes, answer is B. The comptroller and auditor general will appoint the auditor. Question number 10. X purchased a car from Y, believing that Y was legitimate owner. He did not check the registration certificate of the car. Y's ownership. Y was not the rightful owner and the car had been stolen. Tell me, what is the answer? Do you think that it's in good faith? Answer is, see, there are two things here. The definition, section 3 clause 22 of the General Clauses Act is telling you have to take honestly where negligence, in good faith, negligence or not. So this is negligent. This thing is negligent. He did not check the registration certificate, but there is also a provision where due care and attention with prudence should be taken. Yes, due care, sir, please try to understand. Good faith question is a repeated question in General Clauses Act. Yeah. So due care and attention with prudence should be taken. So no proper inquiry. That is cannot be said in good faith. Has not taken good faith. So can he hold a valid ownership because he was negligent? Answer is no. YX does not hold valid ownership because his purchase was made without due care and attention, even though he acted honestly. Sir. Yes. So MCQ is over. Yeah. So next coming to descriptive question. Question number 11. XYZ Limited issued a prospectus to raise funds, investment opportunities in a different industry 6 months later. The proposed investment trading in equity shares of other listed companies. The board of directors suggests varying the original objectives for which the funds were raised to allow new investment and passing a special resolution. Passing a special resolution is the promoters and controlling shareholders supported this change. Some shareholders expresses concern regarding deviation from the initially stated purpose of funds. Is it valid? Is this advice valid? Tell me the provision. Shall we write this provision? Yes. What is the section number? Section number 27. So what is it? What is it telling? Varying objects where money raised through prospectus. Tell me, where you have raised money through prospectus, now you want to change the object, varying object, yeah? So what to do? First, special resolution should be passed and in the general meeting, and you should also do a postal ballot. Yes, next, it should, notice should be given, and advertisement also should be given, and website, in the website also you should place it, yes or no, if you have a website, if any. Third one, dissenting shareholders. Dissenting shareholders. By the way, what is the form number? What is the form number? Form number PAS1. Tell me, dissenting shareholders, can they go for an exit offer? Yes. Exit offer by the promoters is given. They can, if dissenting shareholders want to go out, they can go by promoter and the controlling shareholders. Yes. Next, now tell me, this is the provision, but there is one more provision. What is the provision? You cannot, even though all this is satisfied, not to use it. You cannot use it in what? In buying. You cannot use it in trading or otherwise dealing with the equity shares of other listed companies. Yes, because here they want to do the trading. This, is it valid? No, it is invalid. Please try to understand. If you do not, if you write all this provision, and if you, with the conclusion you are not writing it is invalid, one mark is gone. This, lot of people think that conclusion writing invalid is not, does not matter. It matters, yeah, in your examination. Question number 12. XYZ, sorry, a board proposed, question number 12, board proposed issuing sweet equity share to certain employees and directors, issued ordinarily the ordinary equity shares but has never issued sweat equity shares before. Company has paid up equity share capital of rupees 20 crores. The company has proposed to issue sweat equity shares worth 4 crores of face value. Tell me, if they are asking what the company has approached you to advise them about the issue of sweat equity shares. Just tell me the provision. That's it. Question number 12. What is the section? Sweat equity shares, section 54. A. Shares should be already issued. The shares which they are issuing for security shares should be already issued. B. Special resolution should be passed. C. Approval from the central government or SEBI. Central government if it is a listed, unlisted company, and SEBI if it is a listed company. Yes, D. A notice. In the notice, the number of shares, the price, yes, and who is the employee or director. This should be mentioned. Now is the main point. E. What is the limit? What is the limit? There are two things. One, in one financial year, in one financial year, in a year, you can go higher of 5 crores or 15% of paid up share capital. Yeah, but at any time, overall, at any time, you cannot exceed, you should not exceed 25% of paid up share capital. You should not exceed 25% of paid up share capital. Sir, yes. EF. God, it's going too much. I should have written in the right side. Okay, it's okay. I'll write F here. F. What is the lock-in period? 3 years from date of allotment. G. Registered valuer will give the price and he will do the justification. He will justify it. H. Company will disclose. This company will disclose in form number SH3 and also in the board's report. Company will also do it in the board's report. Yes, SH3. So this is the provision. Now they have how much? Has proposed what, 4 crores, yes, and they have company has already having a equity share of 20 crores, so 15% of 20 crores, 3 crores further, so which is 15% into 3 crores or 5 crores, whichever is higher. How much? 5 crores, but how much are they issuing? They are issuing 4 crores. Any problem? No problem. Yes, this is the answer. Question number 13. PQR Limited, a manufacturing company, is in the process of expanding its operation. To support the expansion, PQR Limited has acquired a plot of land along with the building on it from ABC. The property, however, is subject to an existing charge creating in the favor of bank as security for loan taken by ABC Limited. This charge has been registered by ABC Limited. At that time, the directors of ABC Limited are of the opinion that as the charge for the property was already created, there is no further charge obligated to fulfill the say aside a PQR Limited. After negotiation, transfer of property to PQR Limited with condition that PQR Limited must register a new charge over the acquired property. Tell me, should they? Yes, they should. Yes or no? What is the section number? Section number 79. What is it talking? First, tell me first creation of charge. It is talking about modification of charge. Just tell me, let's also smallly revise creation of charge. Should we, when charge is created, should we do it? Yes, you should create a charge within 30 days of creation of charge in form number CHG1, and this is for creation of charge. And no, the question they are talking about is modification of charge. After acquiring the acquired already charged ones, should you again do the registration? Yes. The charged asset is purchased. If some other company or if one have purchased the charge asset, then they have to inform ROC, inform number CHG1 within 30 days. Sir, they have to inform it. This is question number 13. Question number 14. SAM Private Limited is a subsidiary company of Vishal Limited, where Vishal Limited is not a startup company. It is also provided that SAM Private Limited is also not a startup company. Whether SAM Private Limited is mandatorily required to prepare cash flow statement, considering that he is a small company and he is also a dormant company. What is the answer? First, tell me the provision. What is the provision? Section 2, clause 40. If from the preliminary chapter preliminary one question will come, yeah, a definition will come, this like this a case study only will come. They will not ask a direct question. Yes, just tell me what is a cash flow. They will not ask this. They will ask questions like this. First, so tell me what is the provision for exemption of cash flow statement. Who it is exempted? One person company, small company, dormant company, and startup company. So for this SAM Private Limited, is it exempt? Answer is no. Who said yes? No. Why? Why answer is no? Because a sub because a subsidiary company, which is a private, if subsidiary company is a private company and the holding company is a public company, then what will happen? The subsidiary company will be deemed to be a public company. Yes, yes, Sam Private Limited is having is a subsidiary company, and Vishal is a public company. Because of this, Sam Private Limited will be a public company. It will be deemed as a public company. Because of this, Sam Private Limited has to prepare CFS. Yes or no? Yes. Question number 15. Fran Limited is an unlisted company having its registered office at Agartala. Where is Agartala? Oh God, I forgot the place. Oh, it will start with T. Oh God. Tripura. Yeah, Agartala. The company schedule its annual general meeting in Goa. It is also provided by 1st July 2024. The company has obtained a written consent from all members via email agreeing to hold the annual general meeting at this out of state location. Is it valid? Answer is yes. Tell me what is the provision? Let's write the provision. Section 96 subsection 2. What is it talking? That the annual general meeting should be conducted in the registered office or where city, town or village, the city, town or village where registered office is situated. This is a provision, but for an company, unlisted public company, and the consent, you have got the consent. Either it is in writing or it is in electronic mode. Yes, What consent? Consent from the members, consent from members. I hope you know that this is consent from members. What? That any place in India you can take it. And this consent is taken from everybody, all members. All members, yes, because this is a unlisted company. Where is it? Because this is an unlisted company and all members have agreed to this, they can keep it outside the state, no problem. Based on annual general meeting can be conducted. Question number 16. The company has appointed its statutory auditors, not the first auditor. The board of directors informed the auditor that the fees shall be fixed by the board of directors, but the auditor object the same. Who will fix the fees? Section 142. Auditors remuneration. Who will fix it? One, it will be fixed in the annual general meeting. Two, or it will be in the manner determined in the general meeting. How will it be determined in the general meeting? Who will give the power? The members will be giving the power to the board. Gaining the power. So instead of gaining, I'll write giving. Giving the powers to board of director to decide the remuneration. Yes, this is for what? This is for subsequent. This is for subsequent, not the first one, the subsequent after subsequent or appointment of auditors. So the first auditor will be done by the board will fix it, but after that members only will fix it. But members can, if members don't want to fix it, they can give the power to the board. Yes, so in this case what is the board's recommendation right? No. Question number 17. Priya moved to a new address but forgot to notify the LLP within the required period. A month later, Amit's cousin Ramesh joined LLP as a partner. XYZ LLP did not immediately update the ROC. Priya's address change or Ramesh admission as a partner 2 months after Ramesh joined, LLP filed a notice to ROC about the changes. Tell me, what is the provision? We have to write the provision also, so that is not, I cannot leave that. So I'm really sorry those who think that no sir, finish it over. Because so please try to understand, please, oh god, what did I write here? Please try to understand this, that one day before exam we won't have time to read the entire ones. That's why underlining and writing this provision as side by will help you. That's why I'm telling you, this is what I did, and I help, this is what I tell all my brothers and sisters to do it. Section 25. If there is a partner change to LLP, you have to give, then LLP will give it to the ROC. Yes, you have to give it to the LLP if you have informed. Inform, when you have to inform within 15 days. Partner change happens, then partner have to tell it to you LLP within 15 days in form number 6. Yes, and if not informed, tell me what is the penalty? Penalty is 10,000 rupees. Sir, now should LLP inform to ROC? Yes, they have to inform to ROC within 30 days in form number 6. Yes, and if not informed, if they have not informed, then penalty will be the same 10,000. Yes, this is for the partner change. Oh, no space. But if partner has been appointed, partner has been appointed, then LLP has to inform to ROC. LLP has to inform ROC, yes or no? LLP has to inform ROC within 30 days. Yes, and it has to be signed by the designated partner. Yes, and you have to get the consent of no space, yaar. Yeah, yeah, sign and you have to get the consent of incoming partner. Yes, yes, but if not informed, if not informed, then penalty 10k. 10,000 is the penalty. Yes, if not informed, then penalty is 10,000, and it will be this information will be given in form number 4. Yeah, form 4. Sir. Yes. Question number three more questions. Question number 18. The Parliament recently passed the Protection Amendment Act 2024 disposal. The Act amended the commencement date on, see, what is the commencement date? On 1st September 2024. And the President gave assent. What is the enactment date? What is the enactment date? 15th July 2024. They need to whether they need to immediately comply with the new regulation, or if they have a grace period. Do they have a grace period? Yes, they have a grace period. What is the grace period? 15th of 15th of July to 1st of September. This is the grace period. Yes or no? Yes. Question number 18. Question number 19. Customs and practices. Direct question. Write it. Should I write it? No, right? You will write it. Yes. First, I'll write some 2 points. Custom is the best interpretation of law. This is a common question, custom and practice in interpretation of statute. Contemporia. Law read considering the time, situation when a law was enacted. Yeah, yeah. So, Foreign Exchange Management Act. In April of the current financial year, he accepted a job offer in Canada and left India with a long-term visa to settle in Canada indefinitely. You see, a person resident in India, answer is no. Why? For a, I'll write here. For be to be a resident in India, what should he be? How many days he should stay? He should stay more than 182 days in the preceding financial year. Yes, and but he should not not go outside India for these things. What are those? Employment, business or vocation or any purpose where he doesn't know how many, what is the uncertain period he will stay. Yeah, in this case, is Ravi is going for the employment? Yes. So Ravi is going for employment, so he is PROI. He is not person resident in India, he is person resident outside India. Yes or no? Yes. So like this we have completed the RTP. Yeah. So I hope you have taken all those screenshots, and please subscribe. Next one we will be doing is MTP series. Yeah. So MTP series we'll be doing it. Thank you.